Fourth Amendment to the United States Constitution by Tyler Service, Ottawa University, 327 of 2020. The Fourth Amendment to the United States Constitution is part of the Bill of Rights. It prohibits unreasonable searches and seizures. In addition, it sets requirements for issuing warrants. Warrants must be issued by a judge or magistrate, justified by probable cause, supported by oath or affirmation, and must particularly describe the place to be searched and the person or things to be seized. Let's start off by discussing the citizen's perspective of the Fourth Amendment and what it means to their rights. What does the Fourth Amendment mean to citizens? The Constitution, through the Fourth Amendment, protects people from unreasonable searches and seizures by the government. The Fourth Amendment, however, is not a guarantee against all searches and seizures, but only those that are deemed unreasonable under the law. This is important for citizens to understand because this is not a carte blanche saying that they can never be searched. The Fourth Amendment protects people, not places, and therefore applies as much to the citizen on the streets as well as at home or elsewhere. Citizens should be educated on where and when their rights are protected from search and seizure. So what does this mean for law enforcement? What is the perspective? For starters, the Fourth prohibits more than it actually allows. Police are prohibited in more ways than permitted by the Fourth Amendment. To protect the rights of citizens, police need to follow strict protocols in order to not violate citizens' constitutional rights. One case that is very popular with the Fourth Amendment is Terry v. Ohio. This is also known as the Terry frisk. The court distinguished between an investigatory stop and an arrest, and between a frisk of the outer clothing for weapons and a full-blown search for evidence of crime. The frisk it held was essential to the proper performance of the officer's investigatory duties, for without it, the answer to the police officer may be a bullet, and a loaded pistol discovered during the frisk is admissible. Stop and frisk was granted for the safety of police officers, so officers are allowed to pat the outer clothing of suspects if they have reasonable suspicion that the subject is armed. There are many groups that are fighting to get stop and frisk abolished, but for now it stands as a rightful search and seizure. Warrants are another exception to the Fourth Amendment. Police can obtain warrants where probable cause exists to arrest a subject. Warrants need to be specific in what is to be searched for, where is to be searched, and when it will be searched, and then adding what can be seized. So when does the Fourth Amendment apply to citizens? When does it apply to law enforcement? It is important to be aware that not every search and seizure scrutinized in the state and federal court raises a Fourth Amendment issue. The Fourth Amendment only protects against searches and seizures conducted by the government or pursuant to governmental discretion. Surveillance and investigatory actions taken by strictly private persons, such as private investigators, suspicious spouses, or nosy neighbors, aren't governed by the Fourth Amendment. However, Fourth Amendment concerns do arise when those same actions are taken by a law enforcement official, or a private person working in conjunction with law enforcement. So what this means is that the Fourth Amendment protects against government searches and seizures. Private investigators and average citizens are not held to the same standard. This does not mean any private citizen can violate your privacy because there are privacy laws, but the Fourth Amendment does not apply.